Lujan. She is the special rapporteur of the Human Rights Council of the United Nations for her evaluation of these unilateral coercive measures and their impact in the enjoyment of human rights. Dr. Elena was in Venezuela in February, and she could review in a comprehensive manner the impact of these measures that have been applied by the United States and other countries against Venezuela. And in her report, she described how these measures have affected the human rights of Venezuelans, the right to life, to education, to production in Venezuela, and also they had an impact in income levels in Venezuela. I have to highlight also the importance of Center South joining us. Mr. Carlos Maria Correa is with us. Also important presenters such as Antonio Remiro, Alfred de Sayas, Mr. William Chavez, Ivan Timosev, Richard Falk, Mark Weisbrot, and Jeffrey Sachs that have conducted special research projects on the impact of the coercive measures in Venezuela, and of course, Professor Carmelo Borrego, a Venezuelan professor who's also an expert in this subject. From every single point of view, we deem these unilateral coercive measures as illegal. And for those who are joining us in the different platforms, these so-called sanctions are unilateral coercive measures, and even the United Nations in different discussions and the Human Rights Council of the United Nations has described the coercive character of these measures. However, those arrogant governments, in their desire of domination, keep applying these unilateral measures even during these difficult times for humanity. In this situation with the pandemic that we have experienced in the last years, I know the members of the panels have been able to read the writings of a U.S. expert called Richard Nephew, and this person was the main advisor of President Obama in the application of sanctions against Iran. This person has joined the staff of President Biden, and he wrote a book that for us is a confession, and we have even presented this book as evidence in the International Criminal Court to be included in the docket of the case that Venezuela presented against officials from the U.S. government because of the impacts that the unilateral coercive measures have had as evidence of crimes against mankind. This person made clear that the objective of the unilateral coercive measures is to generate pain. And in fact, in the beginning of his book, The Art of Sanctions, the perspective from the ground, he says direct language needs to be applied, and the intention is to generate pain, to create the conditions to topple the current government so that the government of the country that is receiving the sanctions has a change of behavior and assumes the behavior that the U.S. government wants. This is a flagrant violation to all the elementary principles of international law and a violation to the Charter of the United Nations as well. That is why it's so important that we have an approach, that we develop an approach so that the people and scholars who study this relevant subject may understand the illegal character of these measures. And we have to do it from an academic point of view with And with that purpose, all the panel members can provide their contribution to help us to develop a jurisprudence against coercive unilateral measures so that in the end they can end up being just a memory. For example, to become part of the Human Rights Council of the United Nations, you cannot accept a country that applies coercive unilateral measures or render easier the application of these measures. So this is a debate that must take place at the core of the UN. In 2020, the Secretary General of the United Nations, Antonio Gutierrez, and the High Commissioner for Human Rights, Michelle Bachelet, rapporteurs and specialists from the Human Rights Council, all of them raised their voice so that the government of the US could flexibilize at least or lift and suspend this system of sanction, as they call it, these illegal, coercive, unilateral measures that are being applied against countries such as Cuba, Iran, Venezuela. More than 30 countries are suffering from these unilateral coercive measures because it's hard to make their economies work in the light of these blockades and these systems of unilateral coercive measures that has been promoted by the US. These measures have an extraterritorial character, and due to the domination exercised by the West on the financial system and on the international banking system, it becomes impossible for the states that are targeted with these measures to use the international banks to be able to do their transactions, to purchase food, medicine, inputs, vaccines against the pandemic. Venezuela has $6 billion blocked due to this gold and cash. This money is blocked abroad. 2,000 million in the Bank of England. Even John Bolton, in his famous book that he published last year, he clearly described how the Secretary of Foreign Affairs from the UK committed with John Bolton to ease the blocking of these resources with the purpose of toppling the legitimate government of Venezuela. And this has nothing to do with the violation of human rights or corruption. These are just excuses they are presenting to reframe the Bolivarian government to have access to the resources. Likewise, there is $1.2 billion blocked in a bank in Portugal, and the Portuguese justice intervened and acted, saying that these resources didn't belong to anyone because there were two administrations in Venezuela. They said that. But then it became evident that this was a fiction, this idea promoted by the US. And when they realized about this fact, they said that this money could be derived from narco-trafficking activities. These were just excuses to freeze the assets that belong to Venezuela. The Venezuelan company Citgo, a large industry that belongs to the Venezuelan state and to PDVSA in the United States, with refineries, with hundreds and hundreds of gas stations. They were all confiscated based on a legal maneuver of the US in an attempt to keep the assets of Venezuela. The Venezuelan oil production has been significantly affected. There are several studies that have been conducted, and there is particularly one research project conducted by Francisco Rodriguez and other experts from the US, saying that the Venezuelan oil industry has undergone a process similar to a process that could take place during armed conflict. That is a situation that the Venezuelan industry of oil is undergoing. So there has been a reduction of 99% in the Venezuelan income. Imagine experts and students and all people that are joining this conference. Imagine how a country is dealing with the loss of 99% of income. Out of $100, only $1 has been perceived by the Venezuelan government. However, the Venezuelan government has successfully conducted the social programs. No universities or schools have been closed. The COVID-19 and its effects have been successfully controlled by the Venezuelan government if we compare to the situation in Brazil or Colombia. Venezuela is an exception even in South America with regards to the control of the pandemic. We have received expressions of solidarity to somehow bypass these unilateral coercive measures. We have learned from sister nations such as Iran and Cuba. We have been able to learn, we have been obliged to learn on how to bypass these sanctions, these unilateral coercive measures. We have learned all the strategies in this situation of irregular warfare. We have developed a strategy of defense to be able to sell our oil. And however, for Venezuela, it's very costly to obtain, for example, any product. For example, the face masks of protection, they are more expensive due to the transportation costs when you compare the prices that other countries pay. The insurance policies that we have to pay are almost war insurance policies. Imagine how risky for companies is to trade with Venezuela. So also third parties are affected due to this situation. Even some companies have gone bankrupt. There was a company in Mexico that, due to the fact that they had negotiations with Venezuela to sell trucks, to manage waste and ambulances and other products, most of them humanitarian products, well, this company was sanctioned by the US and their clients got away from this company and they went bankrupt. So imagine the effects of these unilateral coercive measures. So, and I would like to say also, and I would like the panel members to consider this, not only unilateral coercive measures from the wide point of view, but in particular in our continent, in America, in the Americas, where Cuba is, where Nicaragua is, where Venezuela is. Nicaragua is also facing the effects of these coercive measures because there's jurisprudence that was considered démodé, but it is appearing once again, the Monroe Doctrine, in which the US, Washington, considers itself the protector, the police of the continent. From the Mexico to the Patagonia, they feel they're the police of this continent. So they will do everything in their hands to control our governments. When the colonies expanded in the US and they bought part of the Mexican territory, but then later on in a demographic relationship, they didn't need more territory, but they decide in the US, they tried to control the government systems, the economic systems in our countries, the armed forces of our countries, and somehow they made an annexation and an exercise of control. And when a country, for example, such as Cuba, opposes these desires in defense of sovereignty, and also Venezuela, they activate all the mechanisms to avoid this country that tries to resist this domination, and what they use as strategies violates all the principles of international law and the United Nations. It's not the same, obviously, the application of sanction in Cuba or Belarus than in Venezuela, because obviously they apply these sanctions and these unilateral coercive measures with more intensity. So in most of the coup d'etat that took place in our continent, the United States was behind. And Evo Morales once said that in the United States, there has not been a coup d'etat because there's no embassy of the US within US territory. And in the case of Venezuela, in 2019, Venezuela was not behind the coup d'etat, was conducting openly the coup d'etat attempt. So this police of regime change has turned into a comprehensive attack. It's it's not only the unilateral measures. They are conducting an economic attack, a communicational attack, a moral and ideological attack. It's a real attack with mercenaries trying to enter our territories and neighbors, countries that provide support to these mercenaries to enter the Venezuelan territory. And furthermore, the unilateral coercive measures, the blockade, and asking the Venezuelan state to change its government. And with this, I would like to wrap my intervention. And it's important to mention that on February 13, 2020, Venezuela it filed before the International Criminal Court a document that we mentioned before, because we think that there's no doubt that these unilateral coercive measures applied by the United States and also by other governments, but we are describing specifically the measures applied by Washington because they have inflicted damage against our economy and our people. These are crimes against mankind. These are systematic attacks against the Venezuelan population by a state and by an organization, the government of the United States, that have caused death and pain. And we are evidencing before the International Criminal Court the process of application of these measures and the consequences, which is basically a death toll and Venezuelans ill. And this is a case that the International Criminal Court must take seriously, as it has happened until now, but also taking into account quick action, because the more time passes for a decision to be made and to stop the ambitions of Washington, more people will die in our country, in Cuba, in Iran. And we are highlighting the case of Venezuela, but we are also aware of the situation in other countries that have undergone these unilateral coercive measures, and we speak up denouncing their suffering. That's why I wanted to add an anecdote. I'm not a scholar, I'm the Minister of Foreign Affairs, and in my role of Minister of a government that is under siege, we following the instructions of President Nicolas Maduro in the middle of 2019, we held meetings with the person who has been appointed as the person in charge of the Venezuelan affairs in Venezuela. We spoke to Elliot Abrams, who has a terrible background, who was responsible of massacres that took place in the continent. We met him and spoke with us. And even in the first meeting in January 2019, he was saying that there was going to be a coup d'etat. We have the intelligence sources. The military forces of Venezuela are going to back the self-proclaimed President Guaido. And in the second meeting, Elliot Abrams told us the following. Well, I can't concede to you, because we told him the coup d'etat failed, didn't happen. And then he said, we're going to apply against the Venezuelan government maximum pressure, sanctions in all the areas of the Venezuelan economy. You will end up being without gas, without food, without inputs, until the circumstances make possible to have a change of regime or government in your country, one way or another. We, with the dignity that characterizes us, gave him the following answer and told him there's no way the Venezuelan people it's going to accept this pressure. It didn't happen 200 years ago with the Spanish Empire, and it's not going to happen this time with the US Empire. So we let him know that we were going to resist to the uttermost to keep our dignity and to protect our sovereignty and to move forward. And here we are. But we have suffered a great deal. There has been a tremendous cost for the Venezuelan people to be in resistance due to the actions of the US government. And there are the confessions there and books and other pieces of evidence. I'm going to read you this quote from Michael Cossack of April 24, 2020. It's a long quote saying, what the sanctions do is to show the people that there's no hope, that nothing is going to improve until Nicolas Maduro holds power, until he moves away, sanctions will be and continue to be there. This was a confession by an undersecretary of Foreign Affairs of the US, or when Mike Pompeo on April 23rd said, we're going to keep pressuring the regime of Maduro, and at the same time we will provide humanitarian assistance. This is cynicism. Well, we block the providers to Venezuela and we block the market so that Venezuela cannot export oil, but we're going to give you humanitarian assistance. The whole issue about humanitarian assistance and the doctrine of the responsibility to protect, it's taken as an element connected to the unilateral coercive measures and these policies of comprehensive attacks to achieve regime change, or such as Marco Rubio said. In the next week, and this took place in 2019, in the next week, Venezuela is going to face a suffering period that no country in the Southern Hemisphere has faced. Today, Venezuela only has 6 days of supply of gas, and Venezuelans will continue to suffer. Venezuela is going to suffer the most extreme scarcity that has ever lived, with implications we cannot predict. So you can see how they have acted. And there is also a former ambassador of the US in Venezuela. In 2018, he said, we should treat this as a tragedy, as an agony until the ends come. And if we can do something to accelerate this, we need to understand that this is going to have an impact in millions of people that are having difficulties to find food and medicine. We cannot, we should understand that impact is going to take place and until the achievement. Machiavelli, the ends justify the means. No matter if Venezuelans died, as long as the willingness of the US is complied to hold the control on Venezuelan resources, the control in terms of geopolitics over our country, and to stop a process of sovereignty, a political sovereign process that is different from the US. And we could coexist peacefully. We could have a respectful relationship, but it's impossible under the terms that the United States has promoted, and let alone in the face of this cruel attack, this multidimensional attack applied against Venezuela, which has the unilateral sanctions as a central element. These are our contributions. I wanted to thank you once again. The School of International Affairs from Geneva, the Center South, and our permanent mission in Geneva.
Expertos que van a participar y recomendarle a quienes nos escuchan.
And recommend those who are listening to us through the social media
to keep
that these 2 days they should follow closely because we are going to continue for the defense of the peoples for these illegal measures. Thank you very much. And a lot of success during these 2 days of debate. Thank you, Mr. Foreign Minister. Thank you for these comments that will help us a lot. And on these unilateral coercive measures. Before giving the floor to the following speaker, I would like to take the missions that are connected with us. Our ambassador from Nicaragua, connected right now. Also
Qatar and Zimbabwe to United Nations in Geneva. Thank you very much for your presence and your participation in this important activity. I also want to take this opportunity to give a brief salutation to our dear colleagues of Pakistan, China, India, Iran, Sri Lanka, Belarus, Russia, and Iraq, who are also connected in our webinar. Thank you very much. And to all the delegates which are now connected from Zoom or YouTube, thank you very much for sharing with us this important activity. También quisiera saludar finalmente.
Also, I would like to thank those who are following us around the world, who are listening and learning from this important debate on the unilateral coercive measures. Dear friends, it is indeed a pleasure now and an honor to introduce our first speaker, Professor Alina Duhan, the United Nations Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. Professor Duhan is a professor of international law at the Belarusian State University, Minsk, and she has a vast experience in teaching and research in international law, unilateral coercive measures, human rights, and the right on international security, international organizations, the settlement of international disputes, and international environmental law, a wide variety of topics. She has been vice president of International University Mixo in Belarus between 1916 19, author of more than 120 books and articles on various aspects of international law, with more than 40 publications related to international human rights. The presentation of Professor Duhan will first on the unilateral sanctions within the international law. We have given an initial time of 15 minutes for each speaker, and of course, with some flexibility. This important international seminar. You have the floor, Elena Duhan. And I thank you very much. And it is indeed an honor to have you as our first panelist.
Thank you very much, Your Excellency. It's a pleasure for me to participate in this webinar. And first of all, I would like to thank organizers for doing efforts to establish that. And secondly, I would like to thank the organizers for pioneering of establishing academic discussion of the role of unilateral sanctions in the sphere of international law. and in the sphere of the academic discussion in general. As it has been said in my report presented to the Human Rights Council in 2020, I believe that academic discussion and academic assessment of various problems of application of unilateral coercive measures is an integral part of bringing the rule of law at the international area, as well as of guaranteeing that human rights are observed. That's why I put lots of attention on trying to initiate academic discussion in this sphere, because unfortunately, if we look at the academic databases, if we look at the scope of publication, it will appear that there are numerous works which are done in order to enhance the efficacy of unilateral sanctions or unilateral economic sanctions and to achieve the announced objectives. However, there are very few works which try to assess the legality of application of any unilateral measures. And secondly, there are very few works which even try to assess the humanitarian impact of measures taken. And that's why I believe that academic discussion of legality, of humanitarian impact, of sociological impact, as well as political assessment is very important in this sphere. As a special rapporteur, I hold academic expert meeting in Geneva in April 26 this year, and that was the first one. And one of the recommendations of this meeting, which can basically found on the webpage of my mandate, is to establish a worldwide academic network to bring together academics from all around the world representing different law schools or different academic schools together to start discussion as academics and to develop recommendation as well as assessment in this sphere. The second recommendation, which is also reflected in the recommendations of the expert meeting, was to establish a sort of the academic database. As we all know, it's now very complicated to find any publication, as I have already mentioned. Even those few of them which exist may probably be published in another part of the world or in the languages which we do not speak. And quite often the academic space is a situation when they have a feeling that they are the only one who try to think about the problem. And as a result, there is a problematic to base their research on some other issues. And that's why that was the second recommendations. As a result, I have forwarded a communication to all permanent missions of all states, informing them about the outcome of this expert academic meeting in April, and informing them about my intent to establish an academic network, as well as establishing an academic database to bring publications referring to sanctions all together. And I believe it will be really helpful to start academic discussion in the future. And that's why I would like to use this chance to invite all the participants of the conference to participate in the academic network and establishing of this database. I believe that it will amplify our efforts and our research in this field. Unfortunately, if we look today at the international legal practice, despite all the calls, not only from my side, the calls from the side of state, the calls from the side of NGO, the calls from the side of the UN Secretary General and the UN High Commissioner, the number of unilateral sanctions imposed today all around the world is not becoming smaller. Unfortunately, they are expanding. We face more and more of them every day. Also, unfortunately, we face a diversification of the types of unilateral sanctions, and quite often there are serious disputes whether certain types of activity can be qualified as unilateral coercive measures or not. Because indeed, some types of measures, unilateral measures, can be legally taken at the international area. It may happen that state constitute an unfriendly act in a cause of retortion, which, however, doesn't violate any legal norm, but that's legal from the point of international law. It may also happen that the states take measures in the cause of countermeasures in response to already pre-existed violation of international obligation from the side of another state, and that's also allowed under international law. However, the majority of measures which are applied today unilaterally at the international area doesn't fall under any of these categories which I have already mentioned and doesn't fit the specter of international law. That's why my position is that probably we are now at the starting point when an enormous scope of research shall be done to qualify various types of unilateral activity from the point of international law to persuade the, let's say, the world community and the states that the rule of law shall be observed in this situation. And that's why I would like to use the possibility to speak at today's webinar, probably as not transferring my conclusions about qualification of specific activity at the international area, but sharing my thoughts after being within the mandate for more than 1 year, what areas of international law are affected by application of unilateral sanctions, and what areas of international law shall be academically carefully thought and academically carefully analyzed to be able to qualify situation. If I come to this specter, it's necessary to take into account that the unilateral sanctions today vary a lot. We speak about the so-called primary sanctions, which are imposed against states, economic trade sanctions, financial sanctions, diplomatic sanctions, political sanctions, lots of them in this situation. We can speak about so-called targeted sanctions, which are also primarily when individuals or companies are directly designated for doing something allegedly wrongful. That could be an alleged commission of international crimes, or alleged commission of specific national crimes. It could be a committee doing something what probably is not allegedly, shall not be accepted by the world community or by specific countries, because some individuals and companies are designated for violating human rights or for being not democratic enough or to doing something wrongful against. Some other people are also designated for something that couldn't be qualified as any sort of crime at all or any wrongful act at all, for being associated with someone else or for being a relative of someone else as well. Besides that, we are facing today the expanding number of so-called secondary sanctions, when people and companies are designated for cooperating with someone who has already been listed as a sort of enforcement of primary sanctions. So generally speaking, these people are not accused in doing anything wrongful and are not even alleged to do anything wrongful in this situation. The third type of activity, which can hardly be qualified from, generally speaking, from the point of international law as real sanctions, are enforcement measures which are applied by states to its own nationals as a sort of civil or criminal penalties. We have already heard about cases when specific banks have been sanctioned, have been imposed, fined by the United States for the sums up to $9 billion. Naturally, every company, every country company will get bankrupt after being fined up to $9 billion. And therefore, they would prefer not to risk and not to engage to any sort of activity which may put them under risk. The same situation exists when we speak about the individuals. The people could be sent in jail up to 20 years. If we look at the recent European Union Global Human Rights Act regulation, it directly requests that all member states of the European Union shall develop civil and criminal penalty legislation to guarantee that the European Union sanctions are implemented by all of them and are not circumvented by any national or any relative resident of the European Union. So this form of activity theoretically shouldn't be qualified as sanctions because it's applied by states within its own state. However, that's a sort of enforcement of the primary sanctions or secondary sanctions as well. And that's the part of the system. And naturally, we are observing situation of extraterritorial application of unilateral sanctions. We observe development of the zero risk policy from the side of banks, companies, and states, and we observe over compliance with sanctions. and that the enormous system, which is exacerbated with the development of cyber technologies, which allows states to call for cutting some countries off SWIFT systems, cutting off online bank payments, cutting off access to internet, and many other activities. And this variability of unilateral sanctions makes legal qualification of unilateral measures in general very complicated. It's necessary to analyze every specific part because the international legal norms vary in each of these situations. And therefore, I would like to mention several areas of international law which are, upon my opinion, affected the most by application of unilateral measures, the majority of which will be qualified as unilateral coercive measures because they do not correspond to the rules of international law. The first sphere is the sphere of international security, so the law of international security. Unfortunately, up to now, lots of academic works refer to economic sanctions as something what is much better than the use of force, a soft measure to influence some sort of wrongdoers. And therefore, the law of international security is considered to have nothing to do with application of unilateral sanctions. That's not the truth, unfortunately. I was very happy when last November, the ARIA formula meeting took place within the UN Security Council. It was the first time when the problem of application and consequences of unilateral coercive measures has been discussed at the level of the Security Council. The discussion was very active, and naturally countries demonstrated absolutely opposite position on the point. But it's good at least that the discussion has started. From the academic point of view, there are lots of aspects which are to be discussed and analyzed in this sphere. Quite often, application of unilateral sanctions is discussed as a sort of something what has nothing to do with the UN Security Council or vice versa, as the mechanism to implement relevant resolutions of the UN Security Council. However, in practice, if we will compare the number of people who have or companies which have been designated by the UN Security Council and by state, they are incompatible. And therefore, if we look, for example, again at the practice of the European Union, it directly said that only a limited part of its sanctions intends to implement resolutions of the UN Security Council. However, the European Union believes that it can expand scopes of people and companies and states because they believe that's in the spirit of the UN Security Council resolutions, and they have legitimate objectives to do more to implement the resolution. But the question is, does it have at least anything to do with international law in this sphere? The same practice is taken by lots of other states as well. Another area is the often cited struggle against international terrorism. Lots of states impose unilateral sanctions with reference to struggle against international terrorism, which is supported and led by the UN Security Council. We can always recall that initially, after terrorist attacks of September 11 of 2001, the UN Security Council called all states to take all measures necessary to suppress international terrorism. However, it started to be clear very fast that measures taken by states with a reference to suppression of international terrorism quite often violate human rights enormously. And therefore today, the UN Security Council refers all the time to the need to observe international obligations and to protect human rights. Various mechanisms, including the Special Rapporteur on Human Rights while countering international terrorism, have been established in order to prevent violation of international law and human rights. However, in practice, and I would refer here to the database which has been established by a group of NGOs as concerned the negative humanitarian impact of counter-terrorism measures and sanctions, and the facts cited in this database of human rights violations are enormous. And therefore, it's very easy to refer to known need to counter international terrorism and to impose measures which violate international law with reference to the good objective. Similar situation exists when references to the emergency situation are cited, especially by the United States, as a ground to introduce unilateral sanctions, because something what is happening in the other part of the world may be affecting the security of the state. And in this case, it's not obligatory the security in the political or military sphere. Quite often, human security or social security or whatever security is cited, or no identification takes place. However, the call and reference to security theoretically is considered to give a legitimate possibility to impose unilateral sanctions without any assessment from the side of international law. These are the aspects which shall be analyzed only in the sphere of international security law. And now I'm coming to another area which is very important, the law of international responsibility. This sphere is quite often cited, the only one which is cited quite often, I would say. The problem of application of countermeasures and the possibility to qualify unilateral sanctions as countermeasures is at least recognized. However, unfortunately, sanctioning states are quite often forgetting the criteria when countermeasures or any unilateral measures can be imposed in the course of countermeasures. I'm citing again the discussion at the ARIA formula meeting of the UN Security Council, when sanctioning states were referring to the possibility to announce legitimate, not legal, but legitimate good, common goods objective, and the possibility to apply countermeasures as proportionate to that legitimate objective. The law of international responsibility has nothing to do with that point. The law of international responsibility said that countermeasures can only be taken in response to previous violation of international law by a victim state only, directly affected state only, with some exceptions as concerns violation of erga omnes obligation, and shall be proportionate to the violation which took place, not to the legitimate objective, not to any other purpose, but to the violation which took place. However, unfortunately, quite often unilateral sanctions are taken without any previous violation of international law from the side of state, which is sanctioned at the very end. And as a result, this area of international law is also neglected. I'm coming down to another very important sphere, international economic law. International economic law is the sphere which is considered having nothing to do with application of unilateral sanctions. However, if we will look, for example, at the investment treaties which are affected, at the application of WTO regime and norms of GATT and GATS, we will see that they are affected a lot. Unfortunately, there are very few academic works which analyze how application of unilateral sanctions shall be qualified from the side of international law. When I was preparing, and I'm still preparing my report to the Human Rights Council as concerned the notion, types, and qualification of unilateral sanctions under international law, which will be presented this September, I started to look for materials in this sphere. And surprisingly, I was only able to find a couple of academic works dating back to 1990s, not to this period, 1990s, which seek to analyze the legality of security exceptions of Article 21 of GATT, which is basically what is happening today. Countries are referring to the state of emergency and need to guarantee their security interests as a base to introduce unilateral sanctions. However, if we will look at today's situation, we will see that the European Union is resisting a lot the US practice in its attempt to introduce and to implement sanctions against Venezuela, Iran, Syria, and Cuba. And that's what is in force today. And the European Union, which adopted in 1996 a regulation which seeks to protect its companies and nationals against the US sanctions, extraterritorial application of the US sanctions, has submitted a case to the WTO dispute settlement body, which was withdrawn afterwards. So generally speaking, when we speak about the today's situation and today's qualification from the point of international law, in the sphere of international economic law, this problem is to be searched very carefully. When I was, during our expert meeting in April, only the practitioners which deal with compliance mechanism and attempts to avoid compliance with unilateral sanctions refer to the problems they face under WTO, GATT, and GATS, as well as investment treaties. No academic works exist today, and it's necessary to pay close attention to the problem as well. Another area which is very important is international humanitarian law. Quite often countries which are under sanctions, they are facing the consequences of international or non-international military conflicts. And therefore, application of humanitarian exceptions, any pressure from the side of states as concerns the possibility to deliver humanitarian aid to all country or to the part of the country, only to the part of the country which is controlled by someone else, shall be qualified and shall be assessed as well. I can also cite a very important area of international criminal law. It's the importance of this sphere is illustrated by the US imposition of sanctions against the judges of International Criminal Court. I'm welcoming very much the fact that this executive order has been annulled now. At the same time, we face this case. We have seen the attempt of several professors of from the United States to apply to the US court with the request whether they can teach international criminal law. We have faced situation when lots of people are designated with reference for committing international crimes with no attempt, however, to start any case, although there is such a possibility. We are facing, and I would cite here the referral of Venezuela to bring a case to International Criminal Court. And I'm looking forward very much the decision of International Criminal Court, and I hope that it can be a starting point for developing a valid legal ground and valid qualification in this sphere, because international adjudication is important. So it brings me further to the discussion of the importance of assessment of the role of international adjudication as concerned the application of unilateral sanctions. We face now a growing practice of, for example, European Court of Justice. We face the situation of practice of International Court of Justice as well as International Criminal Court. This area is important. I see that my time is already over. That's why I'm making a final statement. Besides other areas, naturally, I'm omitting the importance of international human rights law because that's one of the areas on which my mandate is focusing today. And I hope very much to persuade other UN human rights institutions as well as other institutions from the UN system to pay close attention to the impact of sanctions, because unfortunately today, international institutions are referring to the obligation of governments only to guarantee the well-being of people in the country. However, in practice, unilateral sanctions quite often prevent governments from exercising the possibility to guarantee the well-being of people on its territory. And that's why these aspects, we come to the law of international organization. So as a final point, upon my opinion, every area of international law is affected today by application of unilateral sanctions. And unilateral sanctions shall be assessed not only from the point of human rights law, but from all areas of international law, because the scope of international obligation affected by them is enormous. And I'm again just want to repeat my invitation to do the research in this sphere, to become a part of the academic network, research network, and to become a part of the establishment of the academic database on the problem. Thank you very much for your attention.
Muchas gracias. Thank you very much to Professor Duhan for her statement, her marvelous statement. Quisiera ahora ofrecer.
Now I would like to give the floor to our next presenter, Professor Antonio Ramiro Broton. Professor Broton is a PhD in law, graduated in the University of Köln, professor of public law and international affairs at the Autonomous University of Madrid, director of the postgraduate Center of Studies of the Research Center Ortega and Gasset, also in Madrid, a member of the Institut International and a member of the Spanish delegation to the European Academy of Science and Arts, among other significant elements from his large curriculum. He has written several books and works and has received several awards and honoris causa doctorates. Professor Broton is going to center his presentation in unilateralism versus multilateralism, particularly the case of unilateral coercive measures. We thank Professor Ramiro Broton for his participation as member of this panel. So the floor is yours, Professor. Thank you. Thank you. Good morning, good afternoon, depending where you are. We, the participants in this conference, are in different places, professors, students, members of the audience. I'm going to try to stick to the time established for each participation, about 15 minutes. And the first thing I would like to say is that not all the coercive measures taken by a state are condemnable in legal terms. First of all, the sovereign state has to protect its legitimate interests by its own means under the cover of international law. In this sense, it can exert influence on others to preserve and satisfy one or other interest through diplomatic, commercial, assistance, cultural, and any other type of relations. Beyond this, if the case takes place, it can adopt retortion measures, unfriendly but not unlawful measures in the broad field in which it can conduct itself with discretion in international relations. Beyond that, it can still count on the so-called countermeasures, once known as an unarmed reprisal as a response of illicit actions. Thus, not everything that is unilateral is unilateralism. Unilateralism entails, in its very meaning, a conduct that is oriented by international law rules. Unilateralism responds to the exercise of power over the observance of the rules. When these do not satisfy the interests of the most powerful, and the latter considers that the infringement of the law will not bring for them any harmful consequence. If not everything unilateral is unilateralism, not everything multilateral is multilateralism. It has been said in international law, and it's in the DNA of multilateralism, and it has been said several times, there is no multilateralism without respect for the rule of law, and this is the key element. It is sometimes used the concept of multilateralism when it's used in vain to legitimize coalitions in violation of fundamental principles of international law, and they are an expression that can be called group unilateralism. In this context, it's worth analyzing coercive unilateral measures. We speak of them in plural because they are presented in clusters, like bombs, diplomatic isolation, trade embargo, financial suffocation, energy communications, food and health supplies, among others, apart from personal sanctions in which the guarantees of the rule of law are conspicuous by their absence. The United States has made these measures the fundamental tool of their foreign policy to stifle dissent. The UCMs are even more terrible when they are intended to produce extraterritorial effects. And these effects are exacerbated by the search of accomplices, the submission of economic operators, and the scandalous recourse to the recognition of fictitious governments. Add to this the criminalization of sovereignty behavior in order to force either the free disposal of natural resources by developing countries or their armament policies, even goes as exorbitant forms of cooperations, and even goes so far to pervert humanitarian assistance by adopting measures that directly affect the civilian population, feeding their hunger, I'm sorry for the oxymoron, attacking their health, and encouraging their despair. These measures are illegal internationally, either because they imply a threat and use of force incompatible with the prohibition codified in Article 2.4 of the United Nations Charter, or because they involve interference in the sovereignty and competence of other states, especially but not only in their internal order. Humanitarian assistance becomes in the hands as an instrument of harassment and intervention. And it is here that the entanglement arises in a decentralized society where everyone is judge and party in its own cause. It brings problems because a great power can practice unbridled unilateralism, trying to turn the normative order of international society into imperial law. We can speak in this sense of an arrogant power. We are historically familiar with its excesses, but more intelligent and dangerous is the exercise of the sly power. The sly power tries to pretend to be multilateralism, but pass off group unilateralism as multilateralism. It's not something new, but it's something that has become more and more alarming, especially in the course of the present century. There is some kind of confiscation of the fundamental principles of international law because there is a double standard of conduct in their own interest under the guise of progressive proposals at the normative level that do not have the necessary institutional complement. Indeed, in the evolutionary process of the principles of the Charter of the United Nations, which replicates and develops the Declaration on the Principles of International Law embodied in Resolution 262525 of October 24, 1970, policies have been promoted and conceptually unobjectionable. It is, in fact, to affirm the right of third party to decide and apply countermeasures in response to violation of peremptory norms of which they would not be direct victims. So too, in sponsoring humanitarian interference on the recycled concept of the responsibility to protect of populations massively and systematically mistreated by their governments. This conceptually is unobjectable. However, in a decentralized and an enormously unequal society, such as the international one, these policies, conceptually blessed, are a source of manichaeism and arbitrariness. In other words, they end up being the cover for illicit acts of interference that contradict the sovereignty and formal equality of states, thanks to twisted qualifications of certain situations, or the creation of alternative reality or post-truth without any kind of institutional control. It is unacceptable for the United States and the European Union and its member countries to claim to represent and non-existent as of today international community, as they do, for example, by presenting as sanctions the coercive measures they apply to third parties, assuming a role of supremacist verticality. Simply arrogant or sly, they're violating the norms and the fundamental principles of international law. Concepts such as humanity, international community, common heritage are empty shells impudently employed. The only coercive measures that can be called sanctions are those adopted or authorized by the Security Council within the framework of the UN Charter. And one of the most perverse expressions of slight power are under the control of a hegemon that then naturalizes their multilateral condition to turn them into its own tools, in collusion with client regimes establishing countries that like to call themselves allies. Regional organizations such as the OAS or military alliances such as NATO are the kind of intergovernmental bodies that deal with the laundering of unilateral coercive measures by transforming them into organic resolutions. How to react to this? Well, in the face of arrogant power and slight power, a power based on solidarity is trying to make headway, applied to the protection of common public goods in the broad arc that ranges from the protection of fundamental rights and freedom on individuals and people to that of a planet threatened by a nature polluted by human action. States whose government develop policies in this direction are now on the right track, and civil society in this phase of globalization can inject blood into their veins. The condemnation in reiterated time against in resolution of the General Assembly of these unilateral measures and the adoption of a solemn declaration along the lines of the Declaration on Principles and other landmark declarations of the General Assembly is certain worth considering. However, it is not a question of sowing the seeds of an emerging norm, as some seem to suggest, but of noting a norm already in force, which should be emphasized in these circumstances. This rule qualifies these unilateral coercive measures, and in particular those seeking extraterritorial effects, as a serious breach of peremptory norms, and consequently supports their non-recognition by third parties in line with rule contained in Article 41.2 of the International Law Commission draft on the international responsibility of state for wrongful acts. The unilateral coercive measures are also presented as a threat to international peace and security. However, resolutions, whether of the General Assembly of the Human Rights Council, have been adopted not by consensus, but with a worrying number of votes against, which makes it necessary to strengthen the grounds for condemnation in order to be justified and to expose through what we call the mobilization of shame those who do not support the resolutions. Consideration should be also given to the request by the General Assembly of an advisory opinion from the International Court of Justice, the creation of institutional mechanisms that could mitigate the effect of unilateral coercive measures, facilitating accountability and due reparation to the victims, the filing of complaints with the Office of the Prosecutor General of the ICC, insofar as the measures may qualify as international crimes. So it might be a useless effort to seek for a solution in the UN because it's the only way out. It would be maybe a futile effort, which is the universal structure of disposal instead. But we must try. Regionalism must be a complement to universalism, or a way to make up for its shortcoming, never an alternative. to speak of blocs, regional or otherwise, confronting each other in the midst of international disorder would undoubtedly be a disturbing regression. The activists of law for a more just order must enlist in the mission of transforming might is right into right is might. But law will be power only when power is supportive, which implies institutional advances that accompany normative ones. To flee forward with principles alone may produce ephemeral joy before inevitably falling into the clutches of slight power. Let us repeat once and again, there can be no progress on norms without strengthening genuinely representative multilateral institutions. Thank you very much.
Muchas gracias al profesor Antonio Remiro Bretons por su siempre brillante verbo.
Thank you, Professor Bretons, for your magnificent ideas, inviting us to a deep reflection on these issues. The whitening of unilateral coercive measures should encourage us to have more research, and the participation of the organizations he mentioned, the OAS and NATO, as organization of whitening. So we have a lot to talk during the question and answer period. And I'd like to remind our numerous participants the Zoom, other platforms that are accompanying us in this activity, that we can associate questions, we can send questions to the chats available in this sense. And there is a team that will be taking care of these questions, so we can later on start this dialogue at the end of the intervention of the speakers. Next, we have our third panelist. It is a pleasure to introduce Professor Alfred de Zayas, well-known former United Nations independent expert on a democratic and equitable international order. Professor de Zayas, who also visited us in Venezuela. He studied history and law in Harvard, where he obtained a PhD in jurisprudence. Also, a PhD in history in Nottingham in Germany, professor of international law in the Diplomacy School of Geneva, among other things I could say about his curriculum. He was also an enthusiastic co-convener of this activity, and I would like to thank him personally for his participation and important support for the success of this activity. Therefore, I give the floor to Professor de Zayas, who is going to talk about unilateral coercive measures violate the sovereignty of states and the right of self-determination of peoples. Professor de Zayas, you have the floor. Thank you very much, Excellencies, colleagues. We can hardly hear you. Yes, you need to be closer to the mic because it's very low, the sound. Well, I'm going to read my presentation so it is easier for the interpreters, and I'm going to stick to the time allocated to me. The regime of unilateral coercive measures constitutes a powerful political weapon that hegemonic states, such as the United States, imposed on less strong states, although these measures have no legal basis in international law. The practice was developed by the United States during the Cold War and intensified in recent years. However, the fact that the United States and other states practice these illegal measures with impunity does not create a new right to legitimize them. Among the sources of international law, the Statute of the International Court of Justice recognizes in Article 38 the general principles of law, including the rule ex injuria non oritur jus, which means that the violation of a rule does not abrogate it.
Profesor, sí, el micrófono se puso en mute. Por favor, vamos a resolver rápidamente.
Ahí vamos.
Allí nuevamente tiene usted audio, por favor. Gracias.
Lo que manifiestamente ocurre es que
What happens is that material violation of the law, although condemned by the United Nations General Assembly and the Human Rights Council, is not punished because the United Nations Security Council does not adopt measures because of the veto of those in states that impose sanctions. Today, there is no effective mechanism to repress the practice. It is therefore urgent to establish a competent judicial body that does not depend on the Security Council. It should be remembered that the norms of customary law can only emerge when there is a widespread practice lasting for a sufficiently long period and with the consent of the vast majority of states, which thus express opinion juries and consider the new practice as binding. The reality is that sanctions are imposed by a small number of powerful states, which count on impunity. It's easy to see that there is a large majority of UN member states that reject the legitimacy of unilateral sanctions, as evidenced by numerous resolutions of the General Assembly and the Human Rights Council, the most recent one adopted on March 23rd, 2021, Resolution 46.5, which reaffirm, among other things, and it is very clear, that no state can resort or foment the use of any type of measures, including economic, political measures, to coerce other states in order to obtain the subordination and the exercise of the sovereign rights and to use any type of advantages, reaffirming also, among others, the principle of equality, sovereign equality of states, the non-intervention and the non-interference in internal affairs, and the freedom of trade, of navigation, which are also enshrined in numerous juridical documents. This resolution has close to 29 operational paragraphs. I'm going to read the first and call upon all states to stop adopting, preserve, apply coercive unilateral measures contrary to international law, in humanitarian law, the UN Charter, and the norms and principles regulating peaceful relations among states, especially coercive measures with extraterritorial effects. The Latin motto, quod licet lovi, non licet bovi, what is allowed to Jupiter is not allowed to the oxen, is not a principle of international law, but a repetition of what we already know from the Melian dialogue in Thucydides' book, The Peloponnesian War. The mighty do as they will, and the weak suffer as they must. So those are the two international norms in use cogents which are violated. First, the right of all states to sovereignty, namely to equality among sovereign states and the exclusive jurisdiction on their own territory. Second, the right of all peoples to choose the type of government that suits them. These norms are reflected in Article 1, 2 of the UN Charter in various resolutions of the General Assembly 2131, 2625, 3281, 3314, etc. And they are reflected in the jurisprudence of the International Court of Justice. Among others, in the cases of the Corfu Channel and Nicaragua against the United States. These norms are also reflected in the regional instruments such as the Charter of the Organizations of American States. Particularly relevant are Articles 19 and 20 of the OAS Charter. It's amazing that Almagro behaves in the way he does. And the United States, Colombia, and Brazil ignore these articles of the UAS Charter that says that no state or group of states has the right to intervene directly or indirectly and for any reason whatsoever in the internal or external affairs of any other state or group of states. They could foster coercive economic and political measures to violate the sovereign will of other states and to obtain any type of advantage. With regard to the right of self-determination of peoples, Article 1 of the International Covenant on Civil and Political Rights and the same article of the Covenant on Economic, Social, Cultural Rights stipulates all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. To attain these purposes, all people could dispose freely of their natural wealth and resources, and in no case may a people be deprived of its own means of subsistence. The states parties to the present covenant shall, and it is compelling, binding, promote the realization of the right of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. The resolutions of the General Assembly and of the Human Rights Council they continue to be ignored by the United States, United Kingdom, the European Union, and so on. They are state parties to this covenant. So we are not creating a new right. We are demanding that the right that already exists be respected. The unilateral coercive measures applied by the United States against Cuba are an iconic and emblematic case. The United Nations General Assembly, the universal body representing the international community, has condemned in 28 resolutions these unilateral coercive measures. I've just consulted the draft resolution for the 76th session of the General Assembly, which will be discussed on June the 23rd of this year. The text has the support of the Group of 77 in China, the Non-Aligned Movements, CELAC, the African Union, almost the entire international community, with only 3 votes against: the United States, Israel, and Brazil. The resolution is could be applied mutatis mutandis with respect to all the states suffering unilateral coercive measures. It is not only violation of international law, freedom of navigation and trade, but it's also about crimes against humanity, since sanctions kill. In 2019, the Cuban Foreign Minister Bruno Rodriguez said before the General Assembly the blockade violates the right to life, as formulated in Article 3 of the Universal Declaration of Human Rights and in the Article 6 of the International Covenant on Civil and Political Rights. I'm going to jump because it's too long. I'm going to say that 187 states coincided in urging the lift these extraterritorial measures that violate entities and persons under the jurisdiction of and the freedom of trade and navigation. I wanted to quote from Elena Duhan's reports and the former Rapporteur Desairi. I'm going to jump this section because you can find them in the website of the United Nations. Suffice to say that they have condemned these unilateral coercive measures and they provide the legal grounds to condemn them. As I say, we are not discovering the Mediterranean. We are not inventing the wheelbarrow. These things already exist and they are part of parcel of international law, jus cogens. But powerful states ignore these principles. What arguments can we have in favor of the United Nations? The representative of the United Nations in the time of Trump defended in 2019 the sovereign right of the United States to choose with whom to have trade. That is true. Now, while this policy does not violate the sovereignty of other states and the right of people to self-determination. No one disputes the right of the United States to their own sovereignty. Now, that is not what is at stake. The actions are not innocent and they are not adopted for internal purposes of the United States. The purpose of the sanctions is to generate effects extraterritorially, attacking the right to life of Cuban, Venezuelan, Syrians, etc., the sovereign right to determine their own government and to have economic, financial relations with other sovereign states. To invoke the doctrine of Monroe in 2021, Senators Marco Rubio and others do, is an aberration, since the Monroe doctrine is contrary to the Charter of the United Nations and is in clear violation of international law in the 21st century. There's a chapter I would like to address, however, we do not have the time, has to say with the obligation to repair, compensate for damages caused by internationally wrongful acts. There is an obligation of the United States and other states that have imposed sanctions to pay compensation for damages caused. And this will get trillions of dollars in the harms caused to Cuba, Nicaragua, Venezuela, Syria, and Iran. In closing, on top of violating the main principles of international law, the unilateral coercive measures violate other rights, including the right to development, and impede the realization of the 17 objectives of sustainable development, especially the first one, the end of poverty, second, food, third, health, fourth, education, sixth, water, seventh, energy, eighth, employment, ninth, infrastructure, 13, climate action, 16th, action for all human rights. And it should also be recalled that Article 1 of the Charter of the United Nations states among its objectives to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and fundamental freedoms for all. It is clear that there is no justification whatsoever for unilateral coercive measures. The official propaganda of the US government and the fake news of the media narrative constitute an insult to our intelligence, a mockery of our citizenship, when the State Department lawyers try to sell the sanctions as legal measures with the noble motivation of persuading those states affected by the sanctions to stop violating the human rights of their citizens. It is imperative to reject this crude epistemological manipulation. There is a shortage of medicines, drugs, and medical equipment in Cuba, Venezuela, and Syria. And I remember when I was rapporteur, for other rapporteurs issued a press release accusing the Venezuelan government of not meeting the needs of food and health of the Venezuelan people. However, they didn't bother to try to find the cause of that. The main cause is that there is an economic warfare, and that is clear. Any objective person can see that when you see what is going on in Venezuela and Cuba, if there is shortages or poverty, this is a direct consequence of sanctions. And these deaths that occur as a result of the sanctions can be imputed to the United States. And they are, because the figure is very high, they constitute a crime against humanity. The last idea I want to convey is that the sanctions can create situations that to do with articles of the United Nations Charter says that these countries should be efficacious measures to prevent threats, since these sanctions are applied precisely to destabilize states and to create chaos. It is clear that they are under the ambit of Article 39 of the Charter that says that the state should assess if there is a threat to peace. The United States, of course, have the veto, and they can block any Security Council resolution. But the International Court of Justice does have the jurisdiction to declare that sanctions constitute a threat to peace, and it has the jurisdiction to determine that they are contrary to international law and U.S. cogence. Thank you very much.
Thank you, Professor de Sayas, for your presentation, for your commitment, particularly when you highlight that sanctions kills. This is an important conclusion that we need to highlight. And you have also pointed out the importance of studying and somehow institutionalizing the topic of the reparations of the damages inflicted by those who have suffered the sanctions, so that victims can receive reparations, because not only states have been affected, but also the population from those states whose rights have been vulnerated. Thank you for your participation.
Before continuing to our next panelist, I would like also to welcome our dear ambassadors from Sri Lanka and Djibouti to United Nations here in Geneva. Thank you very much to be connected with us. And I also want to welcome all the other colleagues which are here now connected with us. We can see deputy permanent representatives and other diplomats from many missions from many friend countries as Madagascar, few countries in Africa, and more countries in Asia. Thank you very much. We are very glad to share with you this important analysis about the unilateral coercive measures. Me place ahora introducir como próximo.
Now I'm going to introduce as the next presenter Professor Carmelo Borrego. Professor Carmelo Borrego is a professor of procedural law at the Central University of Venezuela. He holds a PhD of law from Barcelona University. He has written more than 40 works on criminal, international, and procedural law. He wrote. He's also a guest professor in the Barcelona University and has proposed today as topic of the presentation the extorsive and the jus cogens norms and the protection of the legal right. We welcome Professor Borrego for his participation, and also we are honored with his participation because he's part of the Central University of Venezuela, and we feel very proud to have a great specialist in Venezuela. Dr. Borrego, the floor is yours. Thank you for your participation. He's muted. He's muted. We cannot hear you, Professor. Make sure to unmute yourself. Thank you. Good morning, good afternoon. Greetings to everyone. My presentation will be based on some theoretical aspects based on the methodology of the science of law with regards to the extorsive measures applied against our country, and I'm going to mention some pieces of data I recently received with regards to the consequences derived from the extorsive measures applied against Venezuela. This data comes from a research project conducted by a multidisciplinary team led by Dr. Elsie Rosales and with specialists in economics and with a specialist in actuarial science. The current state of affairs makes us see an intensive use of the unilateral coercive measures. This is it is important here to highlight the illegality of actions committed by international organizations and some states to impose upon other states a particular way of acting, even based on the vulneration of the minimum principles of peaceful coexistence. So there have been 40 resolutions from the Human Rights Council questioning these unilateral coercive measures. And the states usually have means in the middle of a bilateral relationship. The sanctioning state should adjust its behavior. However, these are extorsive measures, and I call them extorsive measures because they're not authorized by international law, let alone they can base the application of these measures on the coercive character of the jus cogens norms. These measures are anti-juridical, anti-legal. because their spirit is opposed to law. Secondly, the illegitimacy of the measures, because no state has power of sanctioning another state, and these are not only illicit international wrongdoings, because these are also hostile actions. So every anti-legal act committed by states generates international responsibility. So these extortive measures are international wrongdoings, and these can be reflected in the transgression of an international norm that generates, as I said, illegal legal responsibility. So this is completely opposed to the mandate of international law. So, for example, with regards to the respect to the sovereignty of the states, so now the question would be, starting from the point that the legal norms are in general contingent norms, the subjects with free will are able to violate certain norms, which gives relativity to persuasion that is especially perceivable in international law. And to focus the topic I'm talking about, the thing is that the illicit wrongdoings committed by states have no legal basis in the description of international law norms, which renders difficult to define the violation to jus cogens norms. The international law norms are normally understood as recommendation without sanctioning effects when they're violated, even if they are jus cogens norms. So bilateral norms, as expressed by several legal specialists, these are incomplete legal norms, but they continue to be mandatory and compulsory, and they generate legal duties. So it's not easy to define the protected entity. The institution of the legal right is not mentioned. And under such circumstances, with regards to the orientation that is provided by the science of law, and especially criminal law, there could be a better definition of an illicit wrongdoing of the state when the entity that is preserved by the norm and the sanctions affecting such a state. Can this happen with the international norms? If we take into account the responsibility derived from the illicit wrongdoings of the state, the most relevant international law norms, and have been mentioned before, are the ones called jus cogens rules. The jus cogens rules at an international level do not admit opposed arguments, because they protect the principles that guarantee the survival of the international community. There's a general idea mentioned here, and it's not defined clearly the object that is protected. So it is said that the jus cogens rules are over the wills of the states, because they cannot be abrogated by agreements subscribed by the states. Therefore, it is said also that according to the general current of international law, that the imperative norms are not reduced to be just a resulting product from the willingness of the states. There are constraints to limit the behavior or the acts of the states. However, it's not easy to say when you are in the presence of jus cogens norms. There is not a list of compulsory norms, and the sensate things to do is to have a better certainty to identify a norm that offers a clear mandate, an entity to be protected, and a path to the legal consequence, what we understand as sanction. But if we take into account the principles of the general theory of law, the norms are valid when they demand procedures that are compulsory, and this only makes sense if what is postulated as a duty has a value. On its part, the jurisprudence and the case law define that jus cogens derives that any act or an obligation that is opposed to these norms is void. And with regards to the Convention for the Prevention of the Crime of Genocide, the court affirmed that the principles that are the basis are recognized principles by all the civilized nations. Out of any conventional bond, there is a common interest of protecting the highest well-being that is the main reason of all the governments. Even if the court didn't clearly state the jus cogens of these rules, leaves to the legal interpreter the spirit of these norms. At plain sight, it seems that these rules are understood as principles, and they're normally common law rules. And apart from this, there are other rules understood as jus cogens and erga omnes obligations. And normally, the International Court of Justice rulings are used as a source for interpretation. And they're normally, the thing is that the jus cogens rules as understood in the international context seem not to be understood clearly based on the effect. They are a valuable resource to define the scopes of an international community. This means, in reality, if we try to define better these are substantive norms that define an obligation that the government has, an erga omnes obligation, as I said before. Maybe it's important to highlight, taking this good idea by Kant with an ideological load, the hypothetical imperatives define a behavior for achieving a particular goal. Maybe, understanding this, we can understand better this idea. So, if a methodology is applied for the understanding of the compulsory rules, the jus cogens rules, they have the scope of reinforcing the essential goals of international community, to identify a purpose and recognizing the principle for its preservation, regardless of their common law character. So, in this scenario established in previous paragraphs, we can see then the definition of these extortive measures and the methodology for their analysis, taking into account the breach of the jus cogens rules. From the perspective of the study of the responsibility of the states for illicit wrongdoings, we can understand that we are seeing measures that are anti-juridical or opposed to the law. What rules are breached based on these extortive measures? We have been able to identify through the resolutions of the Human Rights Council, and they were mentioned before, that these are not countermeasures, that extortive measures in reality are not countermeasures. They are opposed to the international law, especially against the jus cogens rules. As we have affirmed before, and as it was affirmed by the previous presenters. If we take a look to the resolution 2625, we will have a closer idea to the contrast, to the violation of the rules, taking into account behavior, negative and positive behaviors. The violation of the rules represented there is evident. A methodology that is appropriate to understand the scope of these measures and their anti-legal nature is based on knowing what the normative message is all about. How can you identify normative facts and the behavior of the sanctioning state, the state that is applying the extortive measures? The principle of equality of rights and free determination of the peoples expressed in this resolution 2625 of 1970, in that description, the message of protection goes in favor of preserving the equality of the states based on the same principles and obligations. The equality of the states based on the same rights and obligations. So no state can affect the free determination of the peoples to pursue their destiny within the framework of guarantees. So the legal right is based on the sovereign equality of the states and profiles the inviolability of these measures. A negative behavior is affecting this equality to impose a specific criterion opposed to the free determination. That is to say, the anti-rules is acting against the rules. And for that, the ideal vehicle could be structural violence, expressed by these unilateral coercive measures or these extortive measures, as I have defined them, displaying different types of action. In particular, there is an aggression against the economic financial system of a country to produce economic collapse. And this will affect a lot of people due to these actions. So the action is based on a plan, and the authors of these extortive measures expect to receive an outcome. The problem, and the essential problem, is that these coercive measures do not have an express prohibition, excepting from the resolutions that have been made and other statements made in the General Assembly. The disrespect for the rules is a common issue, and depending on the relation of power, the neutralization of this measure is going to be possible. This type of acts opposed to the rules is linked to a confusing kind of discourse, as Ramiro Breton mentioned. So they base these measures on justifications or moral grounds, moral judgments that oppose to rules that establish duties. As a sample of this, the UN Charter promotes a particular type of behavior that is away from this type of extortive measures. And in fact, a referential norm to be taken into account, the damage against the legal right and the sanctions used. This has been mentioned by the resolution 583 that on its article 25 says about circumstances that exclude, it's going to exclude any illicit wrongdoing that is not respecting an imperative international law. This means that even if there is a sort of good idea at the beginning, it's lost when you delve into the general description. But even if you consider that this resolution that I have mentioned, produced in the Inter-American Court of Human Rights, in their International Law Commission, this would be a step to consolidate the sanctioning effect and to give more certainty to persuasion and protection of the legal right, as said by the imperative rules. But beyond this consideration, in which the topic of the responsibility of the states is undefined from the legal point of view, far away from reaching a persuasive effect to avoid the breach of the jus cogens rules, we have to say that there have been variations in international law, and there have been recommendations to the states, and there has been a passage from recommendations to the state to criminal sanctions. So, taking into account the seriousness, the anti-legal behavior of the authors, the statute from the ICC mentions that even in this set of legal rules, there are precautionary measures not to violate the sovereignty of the states. However, there is something mentioned with the purpose of sanctioning some kinds of behavior. There are different elements of behavior mentioned there, starting from the jus cogens rules, especially those that we can take from the above mentioned resolutions 2625 from October 24, 1970. So there is a clear relationship between these rules, perfectly understood, with the unilateral coercive measures, or extortive measures, as I call them, and their correspondence with the legal principles of criminal international law. So the crimes against humanity are prohibited based on punitive approach. So when the rights of people and the right of development of people are affected, so when the imperative law is violated based on these unilateral coercive measures, this breaks the prohibition, and if the inhuman acts that intentionally cause suffering to people, these actions should be considered as crimes against humanity, because the international organizations are not able to impose these sanctions. So the jurisdiction and the factors of jurisdiction, there is an intentional and extortive action opposed to the international law principles in detriment of the international obligations of a state. The impact of these extortive measures, and in particular, in the case of Venezuela, can be observed through the data we have extracted from different research projects and the interdisciplinary projects that have been conducted by Dr. Elsie Rosales, among other specialists. And in particular, we can highlight, let me see if you can see this graphic that I want to share, the data related to the reduction of the oil production, how there was a peak, from a peak of 2,500 barrels per day, reduced dramatically as a consequence of measures. This implied a reduction in the income that Venezuela receives and that is sent to the Central Bank of Venezuela. And we can see the reduction of income in billions of dollars. And here you can see from a peak of 56,000 and a dramatic reduction. So with regards to the export figures of oil exported to the US, how this dramatically dropped to a minimum, almost an inexistent amount of oil barrels exported to the US. And the most important piece of data could be the mortality, the infant mortality rate in our country. The child mortality rate that goes beyond 20%. I correct myself. 20 out of 100,000 inhabitants. So you can see these are realities that are reflected here in this research project, and that is going to continue being complemented. So, summarizing, the path followed, the path to be followed is the one of establishing responsibility of the states. Thank you very much. And sorry if I took too long for my presentation. Thank you, Professor, for sharing with us
el impacto notable de las medidas coercitivas
the
unilaterales
impact of these measures. Similar figures can be found in other countries suffering from the onslaught of these unilateral coercive measures. And we need to continue discussing all the academic elements that you have provided, especially regarding the imperative of states, regarding the international juridical doctrine and the wrongful act that could be derived from the application of these doctrines, and which is a deviation from international law. Now we're going to give the floor to our last speaker. It is a pleasure to introduce Professor Richard Falk, Professor Emeritus of International Law at Princeton University, author and co-author of 20 books, publisher and co-publisher for over 20 books. He was special rapporteur of the United Nations on the situation of human rights in the Palestinian territories occupied since 1967, professor of research of the Orfalea Study of Global International Studies of the University of California. We are extremely pleased with his presence, and thanks for joining this important panel on unilateral coercive measures. His presentation is entitled The Divine Judgment of Postcolonial Empire in Unilateral Sanctions. Mr. Falk is an expert in history, and I'm certain that he will be able to nurture us with his experience.
Dear professor, please, to your statement.
Thank you very much. I want to congratulate the government of Venezuela for organizing this important panel, for highlighting their victimization through a coercive process of unilateral measures that violates the spirit and content of international law. And it's particularly impressive to me that Venezuela should have taken this initiative, because they've long had international law on their side and it hasn't helped them. And they could have mistakenly, in my view, come to the conclusion that it is futile for a country that is the target of this kind of coercion to invoke international law. And calls my attention particularly to an important distinction that has been more or less underlying the presentations we've heard already. And particularly, I think Professor Grotan's emphasis on sly power brought this to the surface. But there's a ambivalence in the relationship between law and power internationally that is not often acknowledged even by international jurists. And I draw that distinction by differentiating what I call hegemonic international law from counter-hegemonic international law. A very good illustration of hegemonic international law was the punishment of German and Japanese military and political leaders after World War II for the crimes they committed. This was hegemonic law in two senses. One, it stretched the existing norms to fit the political agendas of the powerful countries, and it exempted them from criminality, even though some of the most objectionable behavior in World War II was committed by the victors. It often is referred to as victor's justice. And for instance, if the Germans had first developed an atomic bomb and used it, but then went on to lose the war, few would doubt that the German defendants at Nuremberg would have been indicted and convicted for crimes against humanity, because next to Auschwitz, Hiroshima gives one the sense of atrocity that occurred in the course of that war. In other words, it was this use of a weapon of mass destruction against a civilian population and genocide that were the two shocks to the human conscience that occurred in World War II. But the recourse to hegemonic international law made it an effective implementation in controversial circumstances where the law wasn't really so crystallized before Nuremberg, and it was just that the powerful countries could make use of their power to extend the norms and have them implemented. Now, in counter-hegemonic international law, which I think is at the profound foundation of this event, is the notion that effective change also results from controlling the symbolic relationships of states to norms, not the behavioral connections, but the symbolic relationships. Perhaps it becomes clear by reference to the anti-colonial wars, where the weaker side militarily won the wars. And they won the wars essentially because they controlled the symbolic domain of law and morality. And that generated support in terms of political will and global solidarity. In other words, if you look at the outcome of struggle since World War II, the last 75 years, those that have prevailed in the end, often at the cost of great suffering, are the ones that prevail symbolically, and what I call the legitimacy war dimension of conflict, and not those that are in control of the coercive instruments of power. And if there is such a thing as sly power, this is benevolent sly power. That it is it can be interpreted, and I think it fits very well with the Venezuelan circumstance. It can be interpreted as power of the people, as opposed to power of the hegemon. And in the background of why is it that countries like Iran, Cuba, Venezuela, Palestine have law on their side, but are still victimized by international behavior? And I think it becomes clear that the United Nations itself is ambivalent toward which kind of international law it wants to identify with. And that ambivalence is written into the charter in terms of the privileges given to the geopolitical actors, in terms of the veto power and their permanent membership in the Security Council. In effect, what the veto power conveys is that the most powerful countries, as of 1945, are exempted from international law if they so desire, and exempted from the UN Charter. They are not accountable. And they're legal, in one sense, legally not accountable. They're empowered to be non-accountable. There were good political reasons for doing this, but it creates this unfortunate situation where the UN can be very important in the symbolic domain of international law. It can legitimize the grievances of a country like Venezuela, but it can't correct those grievances because it's opposed by countries that have the capacity to block implementation of the norms. And it's not surprising that sanctions have been used almost exclusively by the former colonial powers and the United States. You notice that China and Russia have never, as far as I know, resorted to this kind of tool in international relations. And so I think it's important to contextualize the use of sanctions and the abuse of sanctions. I think it was pointed out earlier that not every use of sanctions is wrongful from the perspective of the UN Charter. It can be used as a means of averting uses of force or of implementing norms prohibiting aggression. But when it's used punitively, or when it's, as it was after the Iraq War, the so-called first Gulf War, and the American Secretary of State was confronted by the question, was it worth it to maintain sanctions after the war, even though it resulted in the death of 600,000 Iraqi civilians? And her response was, yes, we think it was worth it. A chilling statement, but beyond that, it represented this idea that sanctions are in a sense a discretionary tool of hegemonic international law, and it is often a sinister tool, as those graphs that the last speaker showed at the end of his remarks, the effect on life expectancy of infants and so on. So that what, in a sense, we are talking, why this topic has assumed such importance is that it has become the principal imperial tool in a post-colonial historical period. European colonialism was defeated, but Western imperialism is alive and well. See, and it's that contrast that has caused so much suffering in the last few decades, and victimized those societies that offended not by violating human rights or committing crimes themselves, but either by adopting a economic order that was offensive to capitalism, or neoliberal globalization, or was based on economic nationalism. Democratic leaders were overthrown because not that they violated international norms, but that they violated the ideological imperative of sustaining capitalist economic arrangements. One of the first and most vibrant examples of this was the overthrow of Mossadegh in Iran in 1953, because he nationalized the oil industry. And it was a reaction to economic nationalism. And a lot of what Cuba and Venezuela have suffered is a reaction to economic nationalism and nationalism that is directed toward the well-being of people rather than the efficiency of capital. And that's a really fundamental issue. So what I'm really trying to express is that we're dealing with what I call a gray zone of international law, where it can be manipulated in ways that reflect the primacy of geopolitics, as international institutions are manipulated through the same dynamic of the primacy of geopolitics. And what's important and sometimes hard for international law specialists to acknowledge is that the system was designed this way. It's not just a matter of it not working. It is working. See, it is working as it was intended to work. Otherwise, the veto wouldn't make any sense. Why would you want to hold accountable the weakest countries and leave the strongest ones unaccountable? with impunity. So it's that fundamental incoherence that is in this gray zone. And so my final point really is that on one hand, having international law on your side doesn't seem to matter if geopolitics is on the other side. See, it matters if geopolitics is on your side, but if it's aligned against you, then it doesn't seem to matter. And what I'm saying is it doesn't seem to matter, but it really does matter. And it really does matter because victory in the legitimacy war is a very strong indicator of who will control the political outcome of conflict. I call this sometimes the unlearned lesson of the Vietnam War, where the US controlled everything in the military side of the war, yet it lost the war. And it never wants to learn that lesson because it can't give up the military side of its whole security conception that has been long understood to be a military industrial academic complex. And it's heavily overinvested in the military. Part of its decline is I think, correctly attributed to this overinvestment in the military and its inability to recognize the limitations of coercive measures and unilateral politics. And so it's extremely creative and constructive, in my view, to take this symbolic role of international law seriously and to keep asserting the counter-hegemonic potential that exists within international law. People said for a long time the ICC, the International Criminal Justice, could only work in relation to third world dictators, especially in Africa. But lo and behold, it endorsed a judgment a few months ago to investigate Israeli criminality and US criminality in Afghanistan a few months earlier. Of course, that created outrage in these centers of geopolitical influence, but it illustrates that insisting on the application of these fundamental norms like non-intervention, crimes against humanity, self-determination, that there is a potential for discrediting hegemonic behavior. And discrediting hegemonic behavior raises the morale of those who are struggling for justice. And it raises increases the solidarity of people and progressive governments and movements throughout the world. So I'm trying to impart the message that international law has not seemed to help Venezuela, but it is very appropriate and I would say necessary that it continues to claim its victimization in relation to the norms of international law. Thank you very much.
Muchas gracias, Professor Falk.
Thank you, Professor Falk.
for your lesson, which was indeed very important. Muchas gracias, estimado profesor.
Thank you, dear professor. Now, this is the final presentation. It was quite important, highlighting the use of international law to denounce the situation, and when there is a collision between geopolitics and international law, that generates the consequences we are seeing in the international scenario and in multilateralism. Dear friends and colleagues, we have received several questions and comments. We thank you for your participation and the interest you have expressed in the different social media platforms that we're using to broadcast this activity. We're going to use these final minutes to respond those questions. Maybe we can take some extra minutes to respond to those questions, given the magnitude and the depth of the different presentations. We have received also some requests from friends, ambassadors to the United Nations to offer also a message of support, of encouragement to this activity. So before starting the Q&A sessions, we have a number of questions, and we're going to select some of them to be answered. But before that, I would like to ask to those ambassadors that have asked for the right to address the floor, may provide their greetings and make their comments with regards to this important activity. The first ambassador that is going to address the floor and that has presented excuses because he had too quick. He left a video. The ambassador of the People's Republic of China to the United Nations in Geneva. So let's listen to the remarks of His Excellency Ambassador Shen Su, and then we will start with the question and answer session of our session. So let's listen to the remarks by the ambassador.
About unilateral coercive measures applied to other Excellencies, distinguished guests, dear colleagues. We highly appreciate this international conference co-sponsored by Venezuela and the Geneva School of Diplomacy and International Relations. The international community is gravely concerned about unilateral coercive measures applied to other countries by some Western countries out of their political motives and in an abusive manner. UCMs constitute a serious violation against not only the purposes and principles of the UN Charter, but also sovereign equality of states, which is a fundamental principle of the international law. UCMs are actually totally coercive, bullying in nature. We are deeply concerned over the serious negative impact on human rights entailed by UCMs. For the targeted countries, UCMs have undermined their capability in developing economy and improving people's living standard, rendering serious detrimental impact on various human rights and the welfare of their people. What is more, despite the ongoing COVID-19 pandemics, certain countries are still imposing UCMs on others. This has drastically reduced the ability of the sanctioned countries in addressing the pandemic, thus seriously violate human rights of the local people, especially women, children, and elderly and other vulnerable groups. This is yet another proof that instead of caring about human rights promotion and protection, these Western countries are taking human rights as a tool for their political agenda. The voice against the UCMs is growing. UN Secretary General Antonio Guterres, UN High Commissioner for Human Rights, Madame Bachelet, and the UN Special Rapporteur on the negative impact of UCMs have repeatedly called upon the relevant countries to lift or relax these measures. The international community should jointly oppose UCMs so as to uphold the international order that is based on the international law. We call upon the UN Human Rights Council, the OHCHR, and the special mechanisms to continue to pay particular attention to the negative impact of the UCMs on human rights, and to urge relevant countries to immediately lift UCMs and stop violating human rights of other countries. Thank you very much for your attention.
Muchas gracias al embajador.
Thank you, Ambassador Kang Su, Ambassador of the People's Republic of China to the United Nations, for his important remarks. We have seen that we have also two ambassadors who want to address the floor. We're going to listen to these two ambassadors, and then we will start the Q&A session after the participation of His Excellencies. And then we will listen to the final remarks by His Excellency, the Minister of Foreign Affairs of Venezuela. So before the Q&A session, we're going to listen His Excellency Chandra Pema, Ambassador of the State of Sri Lanka to the United Nations. Thank you.
Please be free to share with us your statement and your intervention in this activity. Excellency, you have the floor.
Thank you so much, Excellency. I couldn't agree more with the words of the distinguished ambassador of China in what he said about UCMs. As for myself, we would like to thank the Mission of Venezuela for organizing this important event and thank all the panelists for their contributions. I found Professor Richard Falk's contribution to be particularly fascinating, and I'm happy to have been able to participate in this event. Sri Lanka has long recognized the negative impact of unilateral coercive measures on the enjoyment of human rights. We believe that UCMs are contrary to international law. The Vienna Declaration and Program of Action has also called upon states to refrain from such unilateral measures. We echo the concerns raised by the Special Rapporteur on the negative impact of unilateral coercive measures and on how unilateral sanctions have resulted in economic, humanitarian, and development crises, and has had a devastating effect upon populations, particularly during the current pandemic situation. We note the statements by the Secretary General, the High Commissioner for Human Rights, certain special procedures, and other UN mechanisms who have highlighted this issue. As a member of the non-aligned movement, Sri Lanka has consistently supported UNHRC and UN General Assembly resolutions on this matter, and we will continue to support initiatives against UCMs in the future as well. I thank you.
Thank you very much, Excellency, for your statement. Now I would like to give the floor to our dear colleague of Iran, His Excellency Mr. Mehdi Aliabadi, Deputy Permanent Representative from Iran to United Nations in Geneva. Please, you have the floor, to be followed by our dear Ambassador of Syria.
Thank you, Ambassador. Excellencies, distinguished academicians, dear participants. At the outset, I would like to express my thanks to the government of Venezuela and the Geneva School of Diplomacy for organizing this academic conference on UCMs, and I appreciate the panelists for their invaluable insights on this very important issue. We commend Venezuela for its outstanding resilience and resistance against inhuman unilateral sanctions, whose only purpose is to bring the targeted nations to their knees through the most abhorrent and atrocious method of economic terrorism. The imposition of unilateral coercive measures in all its form and manifestations contravene the fundamental principles of the UN Charter, preemptory norms, and basic rules of international law and humanitarian law. While states are free to choose their economic partner, they are not authorized under international law to coercively interfere in economic relations of other states by weaponizing their dominant economic or currency power. The UCMs as a whole is a state unilateral act which includes a wide range of punitive and restrictive financial, banking, and commercial measures against another state in pursuit of its foreign policy agendas. The UCMs contradicts the purposes and principles of the Charter of United Nations, including the principle of sovereignty, non-intervention, self-determination, non-discrimination, and peaceful settlement of disputes. Such measures leave sweeping impacts on the targeted people without any discrimination as to age, gender, or status. Called as an illegality, or rather criminality, disguised as lawful, the UCMs are wrongful acts imposed unilaterally and enforced rather collectively by will or by force, by hook or by crook, as they say. Due to the severe humanitarian consequences and malign intentions behind their imposition, UCMs can only be categorized as a criminal acts entailing international responsibility of the sanctioning state and entitle the sanctioned state to seek compensation. UCMs may be regarded as a crime against humanity due to its premeditated consequences on basic human rights of the targeted populations and their lethal impacts on the people through subjecting the people to severe economic hardship and denying their normal access to basic commodities. Unilateral sanctions have caused massive, indiscriminate, arbitrary deaths by starvation, having negative impact on the enjoyment of all human rights, including the right to development, right to life, and right to health. As it has revealed often, there is absolutely no so-called humanitarian exception other than on the paper. UCMs also hinder humanitarian assistance in the event of disaster, as well as deprive patients access to critical and life-saving medicines and medical equipment. The recognition and implementation of UCMs by other states lack any legal or moral justifications and may lead to their complicity to the crimes committed resulting from the UCMs. The states are obliged under international law not to recognize and give any effect to the consequences of any wrongful act. States must ensure that their sovereign rights and privileges, as well as their international human rights obligations, are not compromised as the result of their passive application of secondary sanctions imposed by foreign states. In line with this argument, what is generally referred to as a secondary sanctions entails the responsibility of the states that are enforcing the sanctions either willfully or reluctantly. I thank you, Ms.
Thank you very much to our dear colleague from Iran. And thank you very much to our colleagues, also ambassadors from Syria and from Zimbabwe, for their understanding to take the floor tomorrow, so we can move forward to our questions and answers session. Hemos, como les comenté, recibido...
So I said before, we have received several questions and comments. We're going to try to summarize.
En primer lugar, para el canciller Arriaza, de 4 preguntas, leeremos 2 que tratan y procuran de incorporar el contenido de todas las intervenciones.
The content of all the presentations. What social movements should do to demand the lifting of these unilateral measures and repair for the damages caused? Another question. Climate change and new technologies demand free access to international markets. Sanctions and blockades as an extortion, preventing technological updates which are essential to the countries. What should we do in this case? I would like to modify a little bit the format of this question and answers, and then give the floor to the foreign minister, because he has to leave. Once he intervenes, we can then answer some questions and give the floor to the panelists for them to answer some of the questions. And then, so we start by giving the floor to our foreign minister. Thank you very much, Ambassador. I'd like to thank all of you for participating in this first day of the seminar, especially the panelists. It is clear that these measures not only are illegal, illicit, the extortive measures, as Professor Borrell said. I wanted to intervene before because I need to attend a meeting in the Vice Presidency of the Republic to discuss with the PAHO to discuss about the pandemic and the vaccines, precisely resorting to mechanisms enabling us to have access to those inputs that normally are impeded by the sanctions. Thanks to the World Health Organization, and PAHO, they also suffer pressures. So they do not help Venezuela in this pandemic. And we are in the COVAX mechanism because it's the only way. We have to ensure from the multilateral perspective to obtain the vaccine. But those donating to COVAX also are creating obstacles to prevent Venezuela to have access to the vaccines. Mensch
Hoy, por ejemplo, cumple 43 años la Fundalatin, una organización venezolana de origen católico que ha sido de gran utilidad. Incluso han enviado por sus propios medios a la Corte Penal Internacional, a la Fiscalía de la Corte Penal Internacional, expedientes y testimonios de víctimas de las medidas coercitivas unilaterales. Y al mismo tiempo los movimientos sociales deben estar en la calle, deben articularse para evitar que esas medidas, bueno, precisamente afecten al pueblo que ellos constituyen. Ellos son las primeras víctimas de esas medidas arbitrarias y deben estar movilizados. Y por supuesto el bloqueo, las sanciones evitan no solo la actualización tecnológica, sino incluso el mantenimiento de las tecnologías que poseemos. Aquí hay empresas transnacionales o internacionales como Siemens, como General Electric, que fueron las responsables de instalar el sistema eléctrico nacional en Venezuela, que no vienen a Venezuela a dar asistencia técnica, ni hacer los mantenimientos, que es complejo incluso poder comprar los repuestos, las partes, las piezas para reparar los sistemas que ellos instalaron, o la tecnología de transporte del metro de Caracas, o las tecnologías Philips y Siemens de los equipos médicos, de los resonadores magnéticos, de los equipos para la radioterapia, las radiografías, etcétera. Es gran responsabilidad del bloqueo, el no poder ni siquiera mantener en buen estado tecnologías que adquirimos hace tiempo, mucho menos actualizarnos con nuevas tecnologías. Quería solamente cerrar con lo siguiente. Desde Venezuela y otros estados hemos propuesto dos iniciativas. Una, dentro del espíritu y el marco de las Naciones Unidas, es un grupo de estados en defensa de la Carta de las Naciones Unidas. Un grupo donde se han sumado países hermanos como Rusia, como China, por supuesto Irán, Cuba, Siria y otros países que nos acompañan en la defensa de esta carta. No es contra nadie, no es contra un país, es en la defensa de, como decía el profesor Falk, del derecho contrahegemónico que está aquí contemplado. Porque aquí está la esencia de ese derecho internacional público justo, aunque también se pueda considerar que hay cabida para otro tipo de derecho aquí, pero el espíritu de esta carta,
the spirit of this, of the creation of the United Nations must be defended. That's the tool. To this group, several states have incorporated, especially through our office, our mission of Venezuela to the United Nations in New York. I appreciate the words from the ambassadors of Sri Lanka and Iran, and making part of this group is a way to combat the coercive measures, these unilateral coercive measures, and there are other initiatives that is not within the framework of the United Nations, that is an organization of states against the coercive unilateral measures. And this is going to help us to denounce and to oppose and share methods and information and experiences that may help us and other countries that may be targeted with these measures to overcome these hindrances based on the previous experiences. For us, it has been helpful, the experience of Iran and Cuba to challenge, to face the challenges that we have faced. But something more systematic and rigorous as a method, there's also Russia that has been affected. China is also helping us to move towards the correct direction. We wanted to invite the states to take part on these initiatives to counteract these measures and to denounce the instrumentalization of human rights to justify international coercive measures, the weaponizing human rights. It's not fair and it's inconceivable to use sensitive issues such as the human rights and corruption accusations and absurd things such as narco-trafficking accusations. Imagine, President Nicolas Maduro has been accused by the Office of the Prosecutor of New York for being allegedly leading a drug cartel to take Colombian drugs to the rest of the world. Imagine how outrageous this statement has been. This is part of the global attack in which the coercive measures are just part of a multi-dimensional attack that wants to use humanitarian international law as a weapon, ignoring the principles of international law and trying to impose not only to Venezuela but also to other countries doctrines such as the responsibility to protect. See the example of Libya, how much suffering there is due to the interference that took place there. And they have been in a loop of suffering. I thank you for being part. I will continue with my commitments against the blockade and against action to bring relief to the Venezuelan people. Thank you, dear Minister of Foreign Affairs, for your participation. We hope you can be with us tomorrow. And so we thank you. Let's continue with our activity. And now we're going to start with our Q&A session for each one of our presenters, who will have a couple of minutes to offer the comments and responses on these particular questions. We will start with Alena Dukhan. We have received several questions. We will try to summarize them in 3 questions for Professor Durham. The first one is, what is the level of advance in the creation of a binding instrument in the United Nations to regulate and pressure the countries that are creating these sanctions, the sanctioning states? That would be the first question. The second question would be, why does the criminal practice of imposing unilateral coercive measures, which clearly violate international law, go unpunished? And the third question would be, in the negotiations that have taken place in the World Organization of Health, linked to the necessary actions to face the pandemic, it has not been possible that a large number of countries are able to accept the connection between unilateral coercive measures and the capacity of the countries that suffer these measures to be able to provide an appropriate and timely response in the light of the pandemic. Is there any kind of empiric evidence that may show this connection between these unilateral coercive measures and the reduction in the capacity of response of the nations? Those would be the 3 questions for Professor. I'm going to continue reading the questions so that you can prepare your answers. So I'm going to read all of the questions, and I will give the floor to each one of the presenters to respond. For Professor Antonio Ramiro Breton, we have also received 6 questions that we're going to reduce to 3. First, what's the criteria for a sanction to be considered as primary or secondary? Second question, being aware of all the atrocities derived from the application of these unilateral coercive measures, what is necessary to do? What can we do? And the third question, we can say that unilateral coercive measures are a conventional form of warfare, considering their effects. Those would be the 3 questions for Professor Ramiro Breton. For Professor de Zayas, several questions that we will try to summarize as well in 3 questions. First of them, is there any direct relationship between the impact of the unilateral coercive measures and the immigration? Can you offer an example to us? The second question, is it possible to infer that the states that impose these unilateral coercive measures foster migration? And the third question, do the unilateral coercive measures impede or render difficult the access to vaccines and medical treatments in times in which we are making calls for multilateralism? Taking into account the human right to health, what mechanism can be created such as the countries that suffer this type of unilateral measures may have access to the necessary inputs to face the pandemic without having to see the companies that provide such inputs fear of sanctions? And for Professor Carmelo Borrego, also some questions that we're going to summarize as well. First question, in what way can influence the unilateral coercive measures in the continuous deterioration of the difficult situation of international peace and security, in particular with the decision of the US of assuming the power in the international disarmament mechanisms. With regards to, do we have to explore the global military expense because it increased significantly during 2020, which creates an additional asymmetry for the developing nations? In what way can we address this asymmetry? Third question, on the basis of your presentation centered in theoretical aspects, how can a concrete connection can be created between the practice and the theory of international law to allow the development of initiatives to mitigate the effects of the unilateral coercive measures? Finally, a last question. From the plots you shared in the final part of your presentation, it could be said that the unilateral coercive measures are criminal. In what ways the ICC has jurisdiction to be able to make a pronouncement? And finally, for Professor Richard Fogg, there are also some questions. The first question, Professor Fogg, the topic of unilateral coercive measures has a direct incidence that has not been explored in the context of international security. The unilateral coercive measures imposed by the US have had the main scope of affecting emerging economies, affecting their possibilities of technology transfer and development. Can we affirm that these unilateral coercive measures are part of the measures used by the United States and their allies in order to ensure their technology supremacy in the last developments, in particular in the matters of weapons? It's a question. And the second question, it is well known the existence of a direct relationship between disarmament and sustainable development. The question would be, are there any researchers on the effects of the unilateral coercive measures in the area of peace, of security at an international level? And finally, based on a comment made in the chat, we would like you to tell us and give a contribution with regards to the relation between unilateral coercive measures and climate change. These are the different questions that had been made. We have tried to summarize them given the large amount of comments and questions that have taken place. I want to thank all of you for the participation, the questions and comments. So we'll give you from 3 to 5 minutes to all the presenters to provide answers to these questions and somehow wrap up your presentation. So let's start by Professor Elena Durham and continue with the order that we follow for the presentation.
Thank you very much, Your Excellency. To tell the truth, the most complicated problem here is to limit the answers to 3 to 5 minutes. But nevertheless, I will start with answering to the last question, which was asked as concerned the empiric evidences and the problems, the discrepancies countries face during the discussion in WHO. That's the fundamental problem as concerns unilateral coercive measures, because unfortunately it's understood very politically and we face antagonism between two different groups of countries. So sanctioning states and see everything in absolutely white, saying that they have no bad impact and they are aimed to punish a wrongdoer. Sanctioned countries feel all the devastating consequences of application of unilateral coercive measures, and therefore they try to show the evidences. But unfortunately, those who impose unilateral coercive measures, they quite often do not see these evidences and they do not see these consequences. Therefore, upon my opinion, it's very important to rely on evidence-based approach and to show real consequences. I did an attempt to do that in my report to the General Assembly last year, which was devoted to the problem of impact of UCMs in the course of the pandemic on the human rights. Some facts have been presented there, and I'm really grateful to the countries which presented information as well as NGOs. Some other aspects which will be presented during the report on the country visit outcome to Venezuela, because there are lots of facts over there. The problem of humanitarian impact of UCM on the national health systems has been discussed 6 days ago on June 3rd on a huge conference co-organized by 10 countries. And I believe that discussion was very important. However, I would use this chance to say that the role of scholars, countries, and NGOs is very important here to show that UCMs is not something abstract, and the impact of UCMs is not something abstract, that's something what affects human rights and what affects human lives a lot. So these individual cases are important, and there are plenty of evidences about that impact. Then when we are moving to the problem of development of the binding document, unfortunately, we are, upon my opinion, still too far from the point of developing a binding document. It's still discussed that we need to draft a declaration on UCMs, on the negative impact of UCMs, and it's still in the process. Again, because of that opposition between two groups of states and quite often not understanding what is the impact of sanctions and low level of awareness, we can hardly find an agreement between states to conclude a binding document. And if we would imagine to conclude in a treaty, I'm looking forward that it will be signed only by sanctioned state only, and sanctioning state will never ratify it, so it won't have a real impact. Therefore, as for now, it's necessary to raise awareness, to do legal research, to show figures, to show evidences, and as a way to rely on the rule of law as a way to come to certain sort of consensus. And as concerned the criminal responsibility for imposing unilateral coercive measures, again, due to the facts which I have already cited, unfortunately, we're still somehow too far from the point. The referral of the case to ICC by Venezuela is a sort of the first attempt to bring a case to the discussion of international adjudication. The attempts of Iran and Qatar to bring cases to International Court of Justice are also a very good starting point for discussion, but I'm afraid that the real discussing of bringing someone criminally responsible for negative humanitarian impacts of UCMs is somewhere like still far away. But with international bodies, we need to use this as a ground to move ahead. Thank you very much.
Thank you very much, Madam Special Rapporteur. You was very brief indeed. I want to thank you particularly for that. But because you are, I guess, the only lady who is panelist, you should have 1 or 2 more minutes if you want. We can be flexible, of course, not only because your condition, but because the important things that you are teaching to us. If needed, at the end, of course, you will have the floor again if you think that there are more ideas that you need to share with us.
I would be happy to. Thanks a lot.
Thank you. Propongo ahora entonces que vayamos al profesor Antonio Ramiro Breton.
Let's move to Professor Ramiro Breton so that he can offer to us a general overview of the different questions and ideas that were brought forward. Thank you. Unfortunately, well, can you repeat the first question? Because I lost my audio as you were reading. I could listen the second and third, but the first question, I was not sure what was the criterion because I lost my audio. For a sanction to be considered as primary or secondary, what's the criteria? Well, first of all, I don't use the word sanctions because I think it's a battle that we need to wage. I don't accept the word sanction. I use a terminology used by the Security Council, and based on that, I don't know if well, for the unilateral coercive measures to be direct or indirect, that has to do whether first subject is targeted or is there a third party that could be affected by these measures. For example, the companies that refrain from making businesses with the sanctioned states and obey these measures that are applied because these companies may be afraid of losing markets. I'm not sure if the question that was posed has to do with this. Secondly, the future of the unilateral coercive measures. What can we do to combat them? Well, I think fundamentally in those countries that are voting against the resolutions that condemn these measures, we need to try to make contacts in the civil society of those sanctioning countries or have some influence in the public opinion of those countries to raise awareness of what's going on. And many countries in the UN refrain from denouncing these unilateral measures due to the influence of the US, the UE, and their allies. So we need to act socially and in the media of those countries and those societies, raise awareness because somehow there is a kind of ethnocentricity in some societies and they feel that they have moral superiority. So we need to somehow change the public opinion and let them know the consequences of the sanctions. Because there are several critical and elements in those societies. So obviously, governments the governments that dare to act against the unilateral coercive measures also try to raise awareness and to let the public opinion know that these measures inflict damage. So the idea is to reduce the bias that exists in the media and the opinion makers. So these type of things. With regards to whether the unilateral coercive measures are an unconventional war tool, yes. Well, they are tools to continue war, and the coercive measures are some kind of muscle diplomacy, of criminal diplomacy that is similar to a war, because these measures produce death, scarcity, shortages, frustration, and impede the peoples to use their own resources and to develop. So these measures maybe could be similar the damage they produce to when you throw bombs in a place. So I could consider these unilateral coercive measures as weapons of war. Yes.
Muchas gracias, profesor. Ahora invito al profesor.
I'm going to invite Professor Sayas to address the floor and offer final words. Voy a hablar en inglés.
and death, there's
Y
also a nexus between UCMs and migration. The Grupo Sures, one non-governmental organization in Venezuela, and Fundalatin, the oldest human rights non-governmental organization in Venezuela, have published reports and studies and statistics on this nexus. So it's obvious that sanctions or UCMs are a major factor, major push factor in causing people to leave their countries. There is, of course, also the Plan Vuelta a la Patria of the government of Venezuela, which I very much approve of. Because no one actually wants to leave his homeland. You leave your homeland only when you are in extremis, in a situation where the economy has been asphyxiated, you've lost your job, you have family, you have kids, and you want them to have a future. Now, Aris Chatsistefano, a filmmaker in Greece, put out a documentary back in 2019 under the title Make the Economy Scream. That is a quote from Richard Nixon speaking to Henry Kissinger in 2000, and what am I saying, in 1970, when Salvador Allende was elected president of Chile. Nixon called in Kissinger and told him, we will not tolerate another social economic model in Latin America, and we will make the economy scream. That's exactly what the United States since 1999 has been doing against Venezuela, and not only since 2015 and 2017. Now, this film also deals with the question of migration and the fact that the sanctions have led many Venezuelans to migrate, be it to Colombia, be it to Ecuador, be it to Peru, be it to Brazil. Now, the other question concerning the pandemic, concerning the access to vaccines, etc. The Secretary General of the UN, Antonio Guterres, also the High Commissioner for Human Rights, Michelle Bachelet, have repeatedly called for a relaxation or lifting of sanctions now during the period of the pandemic. This is obvious that if you have no access to respirators, you have no access to test kits, you have no access to vaccines, you die. Now, this is an important issue, which I discussed also when I was in Venezuela on official UN mission in November, December 2017. I convened all the United Nations agencies and also some of the regional Latin American agencies in Venezuela to ask them, look, you have to find ways to circumvent the impact of the sanctions. You have to make sure that medicines come through. You have to make sure that foodstuffs and insumos come through. So in particular, WHO and FAO and UNDP entered into concrete cooperation agreements with the government, which no doubt have been very helpful in improving, or rather, at least in limiting the damage of these criminal sanctions. Another possibility, appealing to judicial institutions, international judicial institutions, it would seem to me that not only the General Assembly can adopt under Article 96 of the UN Charter a resolution elevating the legal questions of the illegality of the sanctions, the fact that sanctions kill, can only elevate that to the International Court of Justice asking for an advisory opinion. Well, also the World Health Organization would have competence to do so because it falls within their remit. To the extent that the sanctions have made it very difficult for the sanctioned countries to combat the pandemic, there is a question of international responsibility. You have here an internationally wrongful act by the United States and the countries that impose sanctions. One final thought: I was very much seduced by the words of Professor Antonio Ramiro Bretons. And bottom line here, we are dealing with a situation of systematic destruction of language. We're dealing with Orwellian epistemology. We are dealing with hypocrisy and double standards. And if, it is simply obscene to invoke human rights, to impose sanctions, claiming that it's because you want to bring human rights and democracy back to Cuba or back to Venezuela. So you kill the people, and then you say, but actually we mean well. We want to, the corruption of the very concept of human rights and human dignity, that is what is here at issue. And that goes together with the mainstream media that has flooded us with fake news. And of course, with those international lawyers who sell out, who have flooded us with fake law. Thank you.
Merci beaucoup, cher professeur, pour votre intervention. Et merci par vos soins d'essayer de relier. Je continue à faire l'erreur de parler dans d'autres langues alors que j'ai la traduction en espagnol ouverte, donc je suis désolé par cette complication linguistique.
Muchas gracias.
C'est un bon moment aussi pour remercier les traducteurs, je parle en français aussi, pour faire hommage à notre équipe de traduction. Donc, je vous remercie particulièrement, monsieur el profesor de Salles. Continuamos ahora con el profesor Borrego. Le propongo al profesor Borrego entonces tomar ahora la palabra para poder ofrecer.
We give the floor to Professor Borrego for him to answer the various questions posed after his intervention. So you have the floor, sir. Based on the topic that I addressed, perhaps the key issue is that we need to remove the disguise of these measures. These disguise on the UCMs could be really debatable, but you need to call a spade a spade. There is an exclusive mission, extortative measures, not only by powerful countries, but also by the international bodies, organizations. So we need to set what the moral path is. And that is a source of concern for a while, because this has an impact on peaceful coexistence among states. It is clear that the situation today, and as I said, is not that it's easy to address this issue from a clear juridical standpoint. The internal legal frameworks have perhaps a better response concerning these peculiarities of the extortative measures. The question posed on my presentation forced me to resort to other considerations, and it is difficult with such a short period of time to address those. But for instance, two questions were posed regarding disarmament and the unilateral coercive measures. But here, when we talk about disarmament, we have a key element here, namely, what is more important, a coercive measure, an extortive measure, or to begin a conventional war. It is clear that extortive measures are cheaper from the economic standpoint because you don't need much expense to implement those. It depends on the great lobby and power platform to be able to implement the UCMs. Now, when we deal with theoretical matters and practical matters, it's not that it is a theoretical aspect and we need to disdain it. It is just the basis to explain to give reasonable explanations on a phenomenon that is occurring that we cannot resolve. We are just analyzing the phenomenon. In the internal legal networks or platforms, criminal law has given us some tools in order to address normative issues, especially regarding the negativity of the fact on the breach of fundamental laws and norms affecting the population and the state as a whole, and the link of this conduct and the effect on legal framework and the sanctions. Can we talk about sanctions, really? Well, we can talk about juridical consequences, but we can't reach the questions, the sanctions. The sanctions from the criminal perspective, international criminal perspective, could help. It has its limitations, of course, because we are focusing on international criminal court and the principle of territoriality, nationality, and complementarity. So, from the theoretical standpoint, this shows that this is not very effective. There is no response. So we can't dream of having a punitive measure against these countries. However, from the perspective that we have analyzed, the case of the UCM, at least it has been already, we have filed actions in the International Criminal Court, and this referral has shown the seriousness of these measures, and we need to follow up those proceedings. Concerning the graphs that I showed, I had some time constraints. We will not be able to show them better, but they reflect clearly the problems a country is confronting as a result of these UCM, these extortive measures. From various perspectives, you can see the effect on the oil production, oil sales, infant mortality, So there is an effect, and these consequences mean that there have been results of this UCM. And from the criminal perspective, these are wrongful acts in relation with the legal goods. So it is in this fashion that we need to approach these extortative measures. Thank you very much. Thank you. We give the floor to Richard Falk, who is going to complete his presentation answering the questions that have been posed to him. Thank you very much, Professor Falk.
Thank you, Ambassador. The questions addressed to me were rather general, and I can't do them justice in the short time available. I want to say one thing that applies to these general questions, and that is you have to look at unilateral coercive measures in the specific context of the state and what it's trying to, what the tool is being used to achieve. And so when we look at it in the context of Venezuela, for instance, it is trying to do two things overall: discredit socialism and destabilize the Maduro government sufficiently so that it can't effectively govern at this stage. So the question about whether UCMs are interfering with development is vividly answered in the affirmative in the case of Venezuela, because what the object is, as I suggest, is precisely to make the Maduro government and the socialist commitment perceived as a failure. That is the whole purpose of seeking, and at very great cost to the normative order, as has been pointed out by several of our panelists. When you manipulate to this degree the normative order in order so as to coerce another state to do something that is violating its sovereign rights, you're really inhabiting an Orwellian world where, as Alfred de Vias very clearly, you're assaulting the communicative integrity of language, and without being able to trust language, you cannot really have meaningful debate and discourse, and that's happening in an alarming degree in several important countries and at the international level. And the abuse of this kind of unilateral coercive measure, which is, I pointed out, only is available for use by the strong against the weak. And in the context of Venezuela, it has definitely tried to make the hardship felt by the public to such an extent that it will no longer support the government. And in that sense, it is a fundamental interference with the right to development. As far as peace and disarmament, how they are affected by this kind of gray zone use of coercion that isn't quite a use of force that is addressed in the Charter, but it seeks to achieve some of the same results. And as I was trying to argue, this is a post-colonial imperial practice that seeks to undermine the self-determination of states coercively. And it's not with the weapons of war so much as with the weapons of a kind of aggressive, geopolitically driven diplomacy. And therefore, disarmament and peace in the sense of the absence of war is a parallel preoccupation, and a country like the United States uses it as a way of achieving the results of war without the costs of war. Finally, on the relationship to climate change, the relationship is obviously quite profound, but indirect. It means that the resources of the targeted country cannot be used constructively to deal with global challenges, but must be devoted to the process of resistance to these coercive measures. And again, Venezuela's case is obvious that it can't do anything beyond the challenges posed by these comprehensive, harsh sanctions intended to harm, intended to make life unlivable for the population. And therefore, the problems that are affecting the population in a non-ecological way rather than a political way have to be deferred. And the longer they are deferred, the more expensive becomes adaptation and mitigation, and the prospects for catastrophic damage to a society are increased. So the reliance on UCMs is absolutely at odds with responding responsibly to the climate crisis of our time. And the reasons for undertaking this kind of diplomacy by the United States have nothing to do with its own security or its own well-being. It's really trying to control the lives of another society. And therefore, it is very important to keep the focus on preserving the right of self-determination, which really was the normative underpinning of the great anti-colonial movement that was the most transformative development in the post-World War II period. Let me stop there and thank everyone for a good, stimulating, although very long session.
Muchas gracias, profesor. Efectivamente,
Thank you,
larga.
Professor. Yes, it has been a long and interesting session. We thank you again for your enthusiastic participation as presenters.
It's okay again. Sorry. And as I promised to Madame Duhan, please, I will give her the floor for a few minutes, and then I will do a very brief final remarks, logistically, above all, about our session for tomorrow. But before that, Madame Duhan, please, be free to finish in your very important comments on the issue we are dealing with. Thank you.
Thank you very much, Your Excellency. And thank you very much for the possibility to take a few more minutes. I need to mention that I'm very much inspired by our today's discussion, because indeed, I will align my colleagues that the problem of terminology and problem of qualification and notions is very important today, because the sanctioning states are doing everything what they can to circumvent existing legal norms by inventing new terms and new terminologies. And that's why it becomes very, very dangerous, especially taking into account that on the first glance, it sounds, so the terms may be not scary and legitimate or justifiable. However, that's why the research is very much important. I wanted to mention one point which has already been mentioned, but I will elaborate a little bit on the impact of UCMs on the right to development, as well as other relevant actors. I agree that generally speaking, there is a devastating impact on that regard, and probably not only indirect, but we need to take into account that there is a direct impact on the right to development, which as a result affects not only human rights of those who are already living, but human rights of those who are not born yet. And again, when we speak, for example, about the direct link between the impact of UCMs and, for example, climate change, again, it's not only indirect, it's also direct. When people have to cook on open fire, when people have to use improper means of cleaning water, when there is no possibility to use cleaning systems, filters, and so on and so forth, there is direct impact on the environment, on climate change, on the right to favorable environment. And then the last point I was willing to make concern the humanitarian grounds. We have discussed today the legality, aspects of legality and terminology a lot, but at the same time, we need to take into account that sometimes even the legal action can do an enormous humanitarian harm. As it has been stated by the UN, as the result of assessment of impact of the UN Security Council sanctions, the impact of even legal measures is important and can be enormous. Unfortunately, the assessment of humanitarian impact of the UN Security Council measures is made today, but no humanitarian assessment of impact of unilateral measures is done. And therefore, this mechanism is very important. And when we speak about the further steps, what shall be done? It shall be legal assessment first and work in this direction, but at the same time, the humanitarian assessment second. So every human life does matter, and humanitarian assessment and humanitarian concerns shall always be taken into account. And one proposition which I would like to make at the very end, when we speak about the areas which can't be affected in the humanitarian areas, traditionally, all the resolutions and all documents mention food, health, and these other essential goods. But at the same time, in practice, this notion shall be expanded as far as we're talking about the notions again. If you can't get to the hospitals because you do not have any gasoline, your right to health is affected, even if there is a medicine. If you can't have electricity, and if there is no electricity, your life can't be supported, even if you have a life-saving mechanism, and so on and so forth. And therefore, I believe that on that regard, we shall start thinking about expanding these vital essential goods schemes and vital essential goods commodities and lists which can never be affected, but either whatever forms of measures taken by whatever international body or state. Thank you very much once again.
Thank you very much, dear Madam Special Rapporteur. Muchas gracias, estimadas y estimados amigos. Llegamos así al final.
Thank you, ambassadors and all guests. We are wrapping up this session that extended for 1 more hour. I apologize for this extension of time, but I think you share my same criteria with regards to how enriching and productive this session has been, this first meeting, and the exceptional character of the presentation that have been delivered. I would like to invite you to join us tomorrow at the same time, 9 a.m. of Caracas, 3 p.m. European Central Time, so that you can join us with the second session in this international conference on unilateral coercive measures, disrespect towards international law, and the generation of severe human consequences, that will count on the participation of Professor William Chavas, who is today with us here, Professor Carlos Maria Correa, who's also connected to this session, Professor Mark Weisbrod, and Professor Ivan Timofeyev from Russia, who was also joining this first session, and Professor Jeffrey Sachs. Tomorrow, we'll have closing remarks by Her Excellency Delcy Rodriguez, Executive Vice President of the Bolivarian Republic of Venezuela, and His Excellency the Director of the School of International Diplomacy of Geneva. We're going to use the same link tomorrow that we used to connect today, and we'll follow a similar methodology. To all of you, my gratitude for your participation, and I hope you can join us tomorrow in this space for dialogue and debate, and for the consolidation on the doctrine on the effect of and the impact of unilateral coercive measures. A Bolivarian salutation to all of you. Thank you.